In this video, we are going to speak about the state aid regulation within the European Union. A company which receives government support has an advantage over its competitors. The treaty generally prohibits state aid unless it is justified by reasons of general economic development. To ensure that this prohibition is respected, the European Commission is in charge of ensuring that state aid complies with EU rules. Under Article 107 of the Treaty on the Functioning of the European Union, state aid is defined as an advantage conferred on a selective basis to undertakings by national public authorities. To be considered as an state aid, a measure needs to have these following characteristics. There has been an intervention by the state which can take a variety of forms, for example, grants or tax reliefs. Also, the intervention gives the recipient an advantage on a selective basis, for example, to specific companies or industry sectors or to companies located in specific regions. Competition has been or may be distorted, and finally, the intervention is likely to affect trade between member states. In this context, we are going to analyze this case of the General Court of the European Court of Justice regarding one issue related to state aid regime. In this case, British Aggregates Association was an incorporated association within there was different members of which comprise small excavation companies in the United Kingdom. Aggregates are granular materials used in construction. They might be used as they are, for example, as construction fill, or may be mixed with other materials like cement. The Finance Act 2001 imposed a levy on aggregates in the United Kingdom. This act was amended by the Finance Act the following year. The amended legislation lays down exemptions for aggregates resulting from the extraction of certain minerals. This levy on aggregates will be levied only on virgin aggregate. So it will not be levied on aggregates extracted as by product or waste from other processes. So secondary aggregates, there was no tax under this levy. According to the United Kingdom authorities, the purpose of excluding such products from the scope of this levy is to encourage their use as construction materials and reduce the need for unnecessary extraction of virgin aggregate and its undesirable environmental consequences. EU state aid control requires prior notification of all new aid measures to the Commission, to the European Commission. Member states must wait for the Commission's decision before they can put the measure into effect. For the case of this levy on aggregates, the European Commission decided that this levy did not comprise any elements of state aid in 2002. The Commission stated that the imposition the existence of a levy on the extraction of virgin aggregates will contribute to reduction in the use of non-renewable resources and negative environmental consequences. British Aggregates Association, the association that we have spoken before, brought an action for partial annulment of this decision from the Commission. The General Court dismissed the action in its entirety. British Aggregates Association brought an appeal before the Court of Justice. By one judgment of 2008, the Court of Justice, the European Court of Justice, set aside the judgment of the General Court and referred the case back to the General Court in order to analyze it again. The Court of Justice found that the General Court made some errors of law, some mistake in its decision. By the opinion of the Court of Justice, the General Court misconstrued the concept of aid, in particular the criterion of the selectivity of the advantage, which does not distinguish between the causes or the objective of stated measures, but define them in relation to their effects. So we have to analyze the selectivity of the measure regardless of its objective. So we have to analyze it in an objective context. The General Court also, in the opinion of the Court of Justice, the General Court was not entitled to take into account the environmental objective pursued in order to justify the exclusion from the scope of Article 107 of the treaty. In its second analysis, the General Court stated that, according to British Aggregates Association, in the absence of a clear definition of aggregates, that is the scope of this levy, such an abstention cannot be justified by the argument that the aggregates levy is designed to encourage demand for virgin aggregates to shift toward more environmentally friendly materials. As regards the criterion of the selectivity of the measure, it is necessary, in the opinion of the General Court, it is necessary to consider if a state measure is such as to favor certain undertakings in comparison with other undertakings in a comparable legal and factual situation, in the light of the objective pursued by the measure concerned. In order to classify a domestic tax measure as selective, it is necessary to begin by identifying and examining the common or normal regime applicable in the member state concerned. In this case, the parties, so the General Court, the Commission, and also British Aggregates, acknowledge that the reference framework on the basis of which normal taxation and the existence of any selectivity advantages are to be determined consist of the aggregates levy itself. So in this particular situation, the framework for the comparison was the Aggregate Levy Act, which established a specific tax system applicable to the aggregates sector in the UK, as we have pointed out before. So for the General Court, the normal taxation principle underlying the aggregates levy is the principle of the taxation of the commercial exploitation in the UK of a material that is taxable as an aggregate. So the normal reference framework was this levy in particular. By the opinion of the General Court, the extraction of untaxed materials, particularly slate and clay, is at least equally, if not more harmful to the environment than the extraction of other taxed materials. So it must be concluded that the general exemption of some materials, as clay, for example, has resulted in tax differentiation. Finally, in its decision, the General Court annulled the European Commission decision in what it was established that this aggregates levy was in line with the state aid regime. So finally, the General Court decided that this aggregate levy with only tax virgin aggregate was not in line with the European Union law in this field. Thank you very much for your attention and see you in the next video.